Hello, everyone. Thank you for joining us
hear you on the phone.
For our webinar series. And this specific topic is guardianship for you. We're experiencing a few technical difficulties right now, so we just need a few more minutes to get our presenter connected, and we'll be hopping on shortly. Thank you.
Okay. Can you hear me?
Yep, we got you, Kim. You just have to turn your camera on.
Got you. Okay.
Camera.
Okay.
Hi.
Hello. No worries. We're all.
I'm clicking on the camera.
There you go. You're good.
You got me now? Okay.
Okay.
Thanks.
Okay. So I'm gonna go ahead and get started. Alan, we're on, right?
Yep, we're live broadcasting.
Okay.
Go for it.
All right. So welcome everyone for our hot topic series as we continue our hot topic series in this exciting series that we can't wait for our presenter to share her expertise. I had the pleasure of talking to her a little bit before this, and I was really excited about what she has to offer in her perspective and her experience. So the title of this workshop is Guardianship for You, Learn All the Options. Go ahead, Alan. And as we do with all of our meetings at Person-Centered Services, we start with our mission, vision, and core values. Jen, you want to read those? Oh, I got it. So our mission is to connect people to the care, support, and opportunities that maximize their quality of life. Our vision is a community where all people lead fulfilling lives, and our core values are people, integrity, and trust. So Alan, if you can go to the next, okay, sorry. So our agenda today is we're doing brief introductions, and then we're gonna hop into it. So what is guardianship? Alternatives to guardianship is what we're gonna spend quite a bit of time on, and then a Q&A session. So we're really excited to get started here. And the next slide there, Alan. So you have me as our hosts are me. I'm the Regional Director of Care Coordination for the East. Alan Vaneski, who's a Senior Manager of Community Relations, and Jennifer Clark, who's our Provider Relations Manager. And Kim Weisbeck is our presenter today, and we're super excited. She's a supervising attorney at Disability Rights New York, and again, you know, talking with her as we just helped shape this presentation, it just brought some excitement around her perspective, her approach, and her experience, and I'm really excited for her to share that with you. So we're going to go ahead and get started. So thank you, Kim, for agreeing to present, and take it away.
Okay, thank you very much. I want to thank you for inviting me today to talk a little bit about guardianship. I'm going to do my best to keep this to 30 minutes. I really want to give everyone the opportunity to ask questions, and I really look forward to having a conversation about the topic of guardianship. First off, I want to start with when guardianship traditionally begins. in most instances in surrogates court, Article 17A guardianship is what most of us are going to be talking about when dealing with our loved ones and family members and clients who have intellectual or developmental disabilities. So the first thing is, my loved one is turning 18. Now what? Traditionally, often, parents immediately feel that they need to obtain guardianship over their now adult children. Why is that? It's because of the traditional misconception that guardianship will keep your loved one safe. Guardianship is going to help your child make all the right decisions, and you will be able to protect your loved one by having guardianship over them. There's also another misconception that agencies, care coordination agencies, provider agencies, OPWDD, might feel that guardianship is necessary for people to obtain. And a lot of that comes around the notion that it's convenient for the agency to have a guardian. And it probably is, but it doesn't mean that obtaining guardianship is necessary. Another traditional misconception around the need for guardianship is the notion that your adult child, because they have a disability, may not be capable of making all decisions alone. Next slide, please. So what happens when a person has a guardianship over them? Do they lose all of their rights? Pretty much. Your individual who has a guardianship loses most of their decision-making rights. And I don't need to go through each and every one of these, but essentially, if you have guardianship over an individual, you have the right to decide where that person lives. You have the right to decide where and with whom that person associates, whether they can get married, whether they can have children, how or whether they vote, the power to control money, the ability to make decisions regarding programming and regarding education. Those are all rights that are lost when an individual is living under a guardianship. And that's whether guardianship is coming out of surrogates court or Supreme Court within Article 81 guardianship, although with Article 81 guardianships, those are a little bit more tailored, or a lot more tailored actually, and I'll get into that a little bit later. Next slide, please. So 17A guardianship, like I said, is typically what we're talking about with folks who are receiving services from OPWDD and have intellectual and or developmental disabilities. 17A guardianship is granted by a surrogates court. It's plenary in nature. That means it strips the person of all independent decision-making ability. And the effect of having a 17A guardianship is that it often lowers an individual's self-esteem and motivation to be independent. Having a 17A guardianship can restrict your activities in the community and makes a person more dependent on others to permit community involvement. And as I said before, restricts choices of services and residential alternatives. And ultimately, what I've seen in my practice at Disability Rights New York is that it often creates a real strain on family relationships. Next slide, please. And these are things that a 17A guardianship cannot do, even though often when family members are considering guardianship, this is what they're hoping to achieve. 17A guardianships are not going to actually control the relationships that your loved ones are involved in. 17A guardianships can't control the opinion of the individual who's living under the guardianship. 17A guardianships can't control negative behaviors that family members might be seeking to control. And ultimately, a 17A guardianship can't keep a person safe from their decisions or from their actions. Some examples of what I mean by this. In my practice at Disability Rights New York, We represent a lot of people who are living under guardianship and who are seeking to terminate that guardianship. And we also represent people who are facing and defending against a petition of guardianship, a petition for guardianship. And some of the behaviors that we've seen that family members are seeking to control include romantic relationships. We recently represented an individual whose family didn't like their loved one's choice of partners, and they thought obtaining a 17A guardianship could separate and keep their their adult child, away from the person that they were choosing to spend time with, and also felt that maybe they could keep that person more safe from their choice. And the reality is that having a 17A guardianship can't really control the behaviors. If an individual chooses to leave their residence, they're going to leave the residence whether there's a 17A guardianship or not. So if the idea is to try to control and have some more influence over individual choices, 17A guardianship simply isn't going to be able to achieve that. There's a lot of problems that we see with 17A guardianship, and I've listed some of them here. The process of obtaining a 17A guardianship also often involves using medical records that are obtained without the consent of an adult who's facing the guardianship. In order to obtain the 17A guardianship, a petitioner has to fill out a very brief petition and submit 2 certifications from medical providers. And basically they check boxes on those without giving real detailed information about the individual. And when you're talking about submitting these certifications for an individual who's over the age of 18, it's actually a violation of HIPAA and the patient-doctor privilege to use your adult child's medical records in order to obtain a 17A guardianship. Yet we see it happen all the time across the state, and judges allow it to happen. Other problems with 17A guardianship include a lack of notice to the individual facing guardianship. The reality is, a person who's facing guardianship, if you could go back one, that would really be great, thanks. But the reality is that a person facing a 17A guardianship has no right to ever see the petition that was filed against them alleging that they required guardianship. All a person is entitled to is notice of a court appearance. A person facing 17A guardianship has no right to be represented by an attorney in that proceeding, despite the fact of that they lose all their rights if a 17A guardianship is imposed. A person facing guardianship is often brought into court and explained and told by the judge, a well-meaning judge, and their well-meaning petitioners, and I don't want to take that away from anyone. 99.9% of petitioners seeking guardianship are perfectly well-intentioned and thinking that they're acting out of love for the person that they're seeking guardianship over. But when a person comes to court and they're facing guardianship, they're basically often told that they're just trying to be protected and their family members just want to be able to help them. And so there's a lack of understanding often by the individual facing guardianship about what it really means. Because what a 17A guardianship means is that for the rest of that person's life, they lose control over their self-determination. And finally, another problem with 17A guardianship that we see is that it's based on a diagnosis. It's not based on the actual needs of the individual. Next slide, please. There is another option, and that's Article 81 guardianship out of Supreme Court. I'm going to spend 2 seconds on this. It's often not used for folks with ID and DD, in part because it costs money, unlike surrogates court, to go into Supreme Court and get the guardianship. But the reality is it does provide more due process rights to people who are facing guardianship, and it involves a thorough review of a person's functional abilities and their needs And an Article 81 guardianship is tailored to meet the decision-making needs of the person who is living under guardianship. So it's less restrictive than 17A guardianship. Next slide, please. And we're going to skip through these because I think this PowerPoint is going to be made available to people, but there are different types of 81 guardianships that can be used in an event of, and they're called single transaction 81 guardianships. And basically that's if there is imminent danger of the person, when medical treatment is necessary, to oversee a contract or a trust issue that's happening, a family member or another person can petition the Supreme Court to obtain a short-term guardianship over an individual to accomplish an individual single action that needs to be accomplished. And that is an alternative to a 17A or a full Article 81 guardianship. Next slide, please. So I'm here to tell you, though, that guardianship isn't the only answer. The reality is everyone needs help sometimes with all kinds of things. Every young adult is going to make bad decisions, and whether they have a disability or not, and every adult needs guidance from time to time in making their decisions. So most guardianships are made to help people with either their medical decision making or managing their money, and there are alternatives to guardianship to accomplish those needs. Next slide, please. So, do you need help with money choices? This is a whole list of different alternatives to guardianship that can help support an individual who needs help with those choices, and I'll go through them one by one briefly. Next slide. The first is a really basic one, a joint bank account. You and your loved one decide to open a bank account together. Either one of you can put money in and either one of you can take money out. And for an individual, that means that the other person who's making that bank account with you can help keep track of your money and help with repeating payments, things like rent and insurance, and do automatic payments through that bank account. Next slide. Some of these get a little bit more complicated. Power of attorney. This is a legal document. It gives someone that you choose the ability to make certain decisions for you. And the person who is the decision maker is restricted to being able to make the types of decisions that are agreed upon and written into the document. A power of attorney can be revoked by the individual who's giving up the decision-making power at any time. The powers of the agent, who is the person who has the power of attorney, can be very broad or they can be very narrow. And those powers can be effective immediately or they can be effective upon the happening of some future event. Next slide. Another way to help support people in making financial decision making is called an ABLE account. And ABLE accounts are, the earnings in them are tax deferred and they can be tax free if they're used for qualified disability expenses. Money from an ABLE account can be spent by writing checks or using a debit card. The account owner can authorize someone else to make withdrawals from that account, and that's usually done through a power of attorney agreement. Automatic withdrawals from an ABLE account can be set up to pay reoccurring bills. And there's 4 different investment options when you're opening an ABLE account, and those range from more aggressive to much more conservative accounts. And an important thing to remember is that balances under $100,000 are excluded from the SSI resource limit. So Medicaid eligibility will continue regardless of the balance, but if the account balance exceeds the SSI resource limit temporarily, the benefits are suspended temporarily until the balance goes back down. Another option is a supplemental needs trust. And generally, the purpose of the supplemental needs trust is to enable people with disabilities to preserve their eligibility for government benefits, basically Medicaid and SSI, while providing access to the trust assets that enhance their overall quality of life and things that are not covered by Medicaid. So there's different requirements to set up the SNT, and I'm not going to spend time right now going through kind of the nitty-gritties of the supplemental needs trust because I want to make sure that we have time for conversation. But just know that this is an option, and that trust protects the money, both preserving benefits and also creating a trustee that has to approve the withdrawal of money from that trust. Next slide, please. Another option is a pooled trust, which is like a supplemental needs trust, but an agency rather than an individual manages it. So it's similar, but your money is basically pooled together with a lot of other individuals' money, and the agency acts as the trustee of the money, but also protects that money in the same way. Next slide. Representative payee. One thing to note, a representative payee is not related necessarily to guardianship. It's separate from a guardianship. So you can have a representative payee without having a guardian, and you can have a representative payee and still have a guardian also. And the rep payee basically collects an individual's Social Security benefits, controls those benefits, and makes sure that they are responsible for making sure that the individual's expenses are covered with the benefits. So it creates a real safety net for an individual who receives benefits, and that individual, the recipient of the benefit, can choose who their representative payee is, and there's an obligation on the part of the representative payee to act in the best interests of the beneficiary. Next slide, please. The other main reason that people are seeking 17A guardianships is to help protect their loved ones and help them make medical decisions. This is a list of all the different options that are alternatives to guardianship that can help people make medical decisions. Next slide. One is a simple HIPAA release. An individual can sign a HIPAA release to allow their friends, loved ones, trusted family members, trusted individuals to obtain medical information, to receive records, and to communicate with medical providers, to be present in appointments, and basically just help in the management of all medical issues. Next slide. Healthcare proxy. Healthcare proxy is a legal document where an individual can appoint another person to make healthcare decisions on their behalf if they become unable to make their own decisions. Next slide. Family Healthcare Decisions Act establishes the authority of a patient's family member or close friends to help make medical treatment decisions for a patient who is in the hospital, and if that patient is found by doctors to lack capacity, and that person, the patient, did not previously specify a preference for their treatment, and they don't have a healthcare agent or proxy. So essentially what happens if an individual with a disability is in the hospital and is found to fall under these three categories, then an involved family member is entitled to come in and make medical decisions. If there are no involved family members, then what's called a surrogate decision-making committee kicks in to make decisions on behalf of a person who doesn't have the capacity to make them. Next slide. The surrogate decision-making committee is a committee made up of a volunteer panel that is made up of people who are appointed by the Justice Center. And the people on that panel include a doctor, a lawyer, a former patient or family members of people with developmental disabilities, and an advocate. And what happens is it's much quicker than getting court involvement when an individual who lacks capacity needs to make non-emergency important medical choices and end-of-life choices if they are no longer able to make them themselves and there is not an involved family member who can make those decisions for them. Next slide. MOLST is the medical order for life-sustaining treatment. It's intended for end-of-life and critical medical situations. And every hospital has a MOLST or order. It's signed by a doctor, and there is a there are requirements in the Surrogates Court Procedure Act that make sure that a proper process is followed in enacting the MOLST. And it requires a finding of incapacity to make any healthcare decisions by the attending physician and a concurring opinion by another doctor or a psychologist. And these can be completed for people with no guardians and no healthcare proxy, and it goes into effect immediately. And I need to stress, these are used for people who are in critical condition in the hospital facing end of life. Next slide, please. I touched on this a few slides ago, that there are rights of actively involved family members for people who live in OPWDD operated or certified residences. And this is really important to remember, that even if you don't have a guardianship over your loved one, you have the right, as long as you are an active, involved participant in that individual's life, you will have the right to have a say in or involvement in the medical care, as long as it is welcomed by your loved one with a disability. And what that means is that anytime professional medical treatment is proposed where informed consent is required, if an individual is found to not be able to provide that informed consent, then there's a process that needs to be followed where either a guardian or a spouse or a parent, an actively involved adult child, adult sibling, family member, or finally the informed consent committee, that's more for COVID vaccines, or the surrogate decision-making committee get involved. So the fact that a person is living without a guardianship does not mean that they are living without a safety net in all of these aspects of their lives. Next slide, please. If you are living under guardianship, or you have a guardianship over a family member and you wish to terminate that guardianship because you don't feel that it's needed any longer, or maybe it served its purpose and you don't need it, or maybe you never needed a guardianship and you realize that later in time, you can always call Disability Rights New York. And what we do is we work with the individual to obtain the records. We will meet with you and your supporters to talk about what supports you have and assess your case. And if we agree to represent in a termination or a defense of a guardianship case, we draft and file a petition, we secure witnesses, we prepare witnesses for the hearing. We will negotiate with the guardian or counsel for the guardian to try to resolve the petition, and we represent in court. So we have a fact sheet that there's a link in this PowerPoint too that kind of goes through the process and what it looks like for a person who is seeking to terminate their guardianship. Disability Rights New York only represents people with disabilities, and we only represent when people are seeking to either terminate or defend against their guardianship. Next slide, please. Okay, that is pretty much the end of my presentation. My contact information is at the end on the next slide, but I do want to say that we represent people across the state. We have 3 offices in the state, one in Brooklyn, one in Rochester, and one in Albany, and our services are always free. So I'd really like to open it up to conversation and questions if people have some.
Yeah, Kim, so I'm going to go through the questions here that some people have typed in. So somebody had asked for a copy of the presentation. On your dashboard, you should see two handouts. So you should see the PowerPoint from today that Kim shared, and then the handout that she had offered as well. So please look for that. So somebody had asked for some clarification. Cannot control relationships, but can control who one associates with.
Mm-hmm.
Can you dive into that a little bit?
Sure. What I mean by that, and I'll give some examples. I have represented an individual, or we have represented an individual who was a baseball fan. And this guy lived in a group home in New York State, and he wanted to participate in a baseball league. And his guardian refused to sign the release form to allow him to play baseball. He saw baseball as a way, and it certainly was a way, to interact with peers, to get exercise, to be out in the community. And that's a way that guardianship can control the choices that a person makes and the people that they associate with. What I meant by not being able to control all of that is the example of the romantic relationship. If an individual is involved in a romantic relationship, or what you might consider a toxic friendship, a person who has guardianship over an individual isn't actually with that individual at all times. And they're not going to be able to control who they're talking to on the phone, who they might be emailing, who they might be speaking with in their IRA, who they might be associating with outside of their residence when they're out. So those are things that you can't control by having a 17A guardianship. The police are not going to necessarily get involved when a person calls them because they're unhappy with a friend that their loved one has. The guardianship just you think that maybe you'll be able to have some control, but the reality is you just can't control everything that a person does, and that's not the purpose of having. That's not the purpose of 17A guardianship. Shouldn't be.
Thank you. The next question is, how and where is an ABLE account set up?
That's a really good question, and we don't set them up at Disability Rights New York. I think that you can contact your care coordinator and ask provider agencies for more information about that, or also contact your local bank.
Next question is power of attorney someone that can be chosen by the individual's parents that have passed? Does the individual still have the choice to remove them as their power of attorney?
Okay, I'm not sure I completely understand that. What I can say, an individual who has a power of attorney, can revoke that power of attorney at any time. If a person has a power of attorney over an individual and they pass away, that power of attorney is no longer in effect, unless there is another living person who has a power of attorney that would come into effect if that person dies. I'm not sure if that answers the question.
I think so. So there were two questions. So could the parents of the individual choose somebody, I guess I would say, to surpass them after they pass away?
I don't think so, because the individual would need to agree to that person having the power of attorney. It could always be revoked.
Okay, yep, that answers the question. And then the second part to that question was, does the individual have the choice to remove someone as their power of attorney?
Yes.
Okay. And any other questions, please go ahead and type them into the chat box.
I have a few questions that were sent during the registration process. So you may have covered this a little bit, but I want to ask it. What is the difference between legal guardian, and standby guardian?
Oh, okay. So a standby guardian is designated in an original guardianship proceeding in the petition and appointed by the court. What it really means is we often see it when there's a parent who has guardianship over an adult, and then the standby guardian is there in the case that the original guardian passes away. So if an adult parent becomes elderly and passes away, the standby guardian then can assume the role of guardian. However, the standby guardian would need to go to court and file in surrogate's court to become appointed the guardian. But it's a secondary guardian.
Okay.
Two-part question came in. So first, it says, thank you, Kim. This is great information. I see that your agency is focused on assisting people with disabilities that have had their legal rights stripped. Can you give us an example of a situation in which guardianship makes sense? And then there's another part to that question. I'll let you answer that one first.
Yeah, so where do I think? Well, I think Article 81 guardianship makes sense a lot more often from what I see in our practice than 17A guardianship, but I believe that 17A guardianship definitely has a place, and that place is for individuals who are clearly unable to express their wishes and their needs. For example, an individual who is nonverbal and has a severe disability that results in them being absolutely incapable of making any decisions on their own behalf. Because that is what a 17A guardianship does. It actually makes an individual incapable of making any decisions on their own behalf.
The next part to that is, are there situations where people are looking to have guardianship dissolved, but it may be better for the person seeking that removal to continue their guardianship? And is that a decision that's made by the courts?
That is a decision that's made by the courts. But I will say, we've represented a lot of folks now across the state who are seeking to have their, to remove their guardianship and restore their rights to make their own decisions. Our clients have included people living in the community, residing with their guardians who continue to reside with their guardians after the guardianship is terminated. Our clients have included people living in IRAs. I had a client who I successfully removed his guardianship. He had a full-scale IQ of 53, which was lower than the first percentile. But this person had supports who were there to help him make decisions. He couldn't live independently in the community without assistance, but that didn't mean that he needed a guardian. It meant that he needed to live in a place that he had a lot of supports where people could bring him where he needed to go. People could work with him to help him shop and clean and make food and take his medicine. But that, just because you need those kinds of supports does not mean that you need a plenary guardianship. And I would also note that we have helped people dissolve their guardianships who are college graduates, whose parents were very well intentioned and really felt that they were doing the right thing in getting a 17A guardianship, but it clearly not needed for someone who can go to college unassisted and go out into the community and have a career. So it really runs the gamut.
And Kim, just to kind of piggyback off that, part of why this topic is so timely and so important is that, support structures have changed. Our service delivery system has changed, and things that weren't able to happen, in previous years can happen now. And I think the mindset shift, right, that we're trying to help people understand and change in terms of how they look at guardianship from a control aspect, from a keep people safe, which we want everyone to be safe. That's not what we want, but there's that dignity of risk. right?
Absolutely.
And we need to be able to help folks that we support and loved ones and family members to be able to have control over the life where they can.
Right.
I have a few more questions.
Jason, I've got one more that just came in, if that's okay.
Okay, go ahead.
Yep, thanks. It says, it seems like guardian would control the person's money. Are there any controls on a guardian that is using the person's money for their own purposes?
So I should have said this, and I apologize. There's two types of 17A guardianship, one over the person and one over the property. So sometimes a guardian is the guardian of both the person, and that's the decision making, the medical stuff, and just the everyday living, all the aspects of a person's life. And sometimes it's just property guardian, and often they're both. So if a person has control over, if a property guardian is making poor decisions, one of the shortcomings of the 17A guardianship system is the lack of a requirement for periodic reporting. And that does exist within Article 81 guardianship, but doesn't really exist to that extent with 17A. So there's not a lot of court oversight. Once a guardianship is granted, there's not a lot of control by the court over what that guardian is doing. And you can file a petition in court or just write a letter to the surrogate's court because they have continuing jurisdiction alleging that a guardian is mismanaging a person's money. But it can happen. There's not a lot of control over what goes on. There's a lot of trust. And that's the assumption that a 17A guardianship is looking out for a person's best interest. Unfortunately, it doesn't always work that way, but usually it does.
Thank you. Go ahead with your question, Jason.
Yep. What is the average cost to hire a lawyer to help with this? And at what age should parents begin the process?
I'm not sure if what you're asking, I couldn't give you any information about the process of obtaining a guardian. Mm-hmm. Our services are free. So if a person is facing a guardianship petition, we will represent an individual with a disability at no cost in defending against guardianship. And we will also represent all individuals with disabilities at no cost if they are seeking to remove their guardianship.
Okay, thank you.
You don't need a private attorney to do that, although a person could hire a private attorney to do that.
Yeah. And for our attendees, there are two handouts in the handout section. I know Ellen mentioned that, but I think it's important because there was a section in which Kim, you shared kind of the different I guess avenues for different scenarios to support people, right? And I think that looking at guardianship as kind of the overall, or getting guardianship to be able to make certain decisions is not necessarily something that's needed. There are other avenues, so it's important for us to realize that there are other ways to help our loved ones meet their needs without necessarily obtaining guardianship, that being your path.
Yeah, and one thing that I didn't touch upon that I really wanted to, and I'm not sure if we just went too fast and over the slide, is there's something called supported decision making New York. And supported decision making is a process where an individual with a disability and any supporters that they want involved go through a facilitated process where at the end of the process, they have what's called a supported decision-making agreement. And that agreement is essentially a contract that sort of sets out who this person's supporters are and what types of decisions that each supporter is going to assist the individual in making. And supported decision-making New York is the office that runs it, and it's sdmny.org. And it's really a great process. It's been, the state legislature actually just codified supported decision-making in the New York state law, and it is accepted across our state now as a real alternative to guardianship. And what it does is that it really grants an individual the right to choose who their helpers are and what areas of their life those helpers can get involved and help make decisions.
Mm-hmm. And that kind of goes to the next question. What happens if a parent believes guardianship is necessary, but the young adult wants to manage their own affairs?
Mm-hmm. Then the young adult has the right to go to court and to tell the judge that they want to manage their own affairs, and they have the right to go to court and ask that an attorney be appointed to represent their interests in that matter. And they also have the right to contact our office to seek our representation and our assistance. Also, I think a young adult who does not want a guardianship has the right to speak up to their service providers and let them know what their wishes are, and to ask for help with that regard.
Kim, another question that came in says, do you recommend any agencies such as Future Cares when starting the guardianship process?
I don't, and I think that, you know, what I'm really here to talk about is the alternatives to that guardianship process, and to really point out that guardianship is not needed nearly as often as people think that it's needed. And I really would encourage everyone to consider the alternatives for, you know, so many of the reasons that I stated today, and to really give the benefit of the doubt to your loved ones who have a disability, that, you know, they're actually a lot more capable than they're often given credit for. And, you know, we really support the right of all individuals in self-determination, and that dignity of risk in making choices and then learning from those choices.
Yeah. The last question I have pertains to care coordination. What assistance can be provided by a care coordinator with this process? And I mean, I guess I can answer that, or Jen, do you want to answer that? Can you?
And care coordinators are there to direct them with what the options are along the way, and that's why this is so fantastic. And we did we record this today?
Yes.
Perfect. So this is fantastic, because we're actually going to post this for care coordinators to use this as reference. But care coordinators can direct families to what the alternatives are. They cannot tell a family what they need to do, but they can be a support along the way to say, these are the options that are available for you, and help a family to say, these are the options available for you, so that they can make a correct decision for their family member or loved one.
Thank you, Jen. Those are all the questions we have. Again, there's handouts in the handouts tab on your dashboard. We want to thank Kim for the great presentation. Lots of great information that I know will be helpful. We want to thank you, audience, for participating in this webinar. We have the contact information. Kim's contact information was shown before. These are the contact information for myself, Alan, and Jen. If you need us, Alan, the next slide.
Yep, we'll just mention August 17th at noon, we'll be holding our next Hot Topic webinar. It'll be where do I want to live? Learn about different housing options. So you can go to personcenteredservices.com to register or sign up for our e-news and stay up to date with all the future offerings that we'll hold.
Yes. So thank you all. Have a wonderful rest of the day. Again, thank you, Kim.
Thank you. Thanks for having me.
Thanks so much, Kim.
All right. Bye-bye.